Thank you for joining us. My name is Georgette Vigil. I am the Senior Director for Alumni Engagement and Outreach at Colorado Law. During the presentation, you can ask questions using the Q&A function at the bottom of your screen. Questions will be monitored as they are submitted. You can vote on the questions that interest you the most. Professor Skinner-Thompson will respond to questions following the presentation. As a reminder, everyone is on mute. Now it is my pleasure to introduce the Dean of Colorado Law. Dean Anaya is an internationally recognized scholar and author in international human rights issues concerning Indigenous peoples. He has served as the United Nations Special Rapporteur on Rights of Indigenous Peoples from 2008 to 2014. In addition to his teaching and scholarship, Dean Anaya has litigated major cases involving Indigenous peoples, human rights in domestic and international tribunals. Please join me in welcoming Dean Anaya.
Thank you, Georgette, and hello, everybody. I hope you're all doing well. Welcome to this evening's Colorado Law Talk, Privacy at the Margins, presented by Scott Skinner-Thompson. I know there's a lot going on in our country and in the world right now. We genuinely appreciate your taking a few minutes or an hour or so to be with us this evening. Before we begin, I'd like to recognize that the University of Colorado is located within the Ute, Cheyenne, and Arapaho Peoples territories. And further, we acknowledge that 48 contemporary tribal nations are historically tied to the lands that make up the state of Colorado. I'd also like to acknowledge that today is Veterans Day. We honor the sacrifices made by all those who have served in the United States military, including any active duty and former military personnel who are joining us this evening. The Colorado Law Talks series was launched in 2017 to share the groundbreaking research, knowledge, and ideas of the Colorado Law faculty with a broader legal community in the Denver area, and especially now that we've gone virtual with the legal community throughout the state and beyond. The mission of Colorado Law includes not just providing exceptional legal education, but also engaging in research and producing influential scholarship with real impact in the world. And this scholarship, of course, advances our public service mission. Professor Scott Skinner-Thompson is a leading scholar whose work addresses important issues that are important to society in the areas of constitutional law, civil rights, and privacy, especially as these areas relate to LGBTQ+ and HIV issues. This year, Cambridge University Press published his book, Privacy at the Margins, which is the subject of his talk this evening. Erwin Chemerinsky, a dean at the University of California, Berkeley, and one of the country's leading scholars and authors, has described this work as, and I'm quoting, an enormously important book about a crucial aspect of privacy law that has been overlooked, the way in which it affects historically discriminated against individuals. Professor Scott Skinner-Thompson is a graduate of Whitman College and Duke Law School. He joined the faculty of Colorado Law in 2017. And you can find out more about his impressive background in the detailed biography that's been made available to you. I'm delighted to now turn the program over to Scott.
Well, thanks so much, Jim, Dean Anaya, for having me, inviting me to give this talk, and thanks so much to Georgette Vigil and Yesenia Delgado, and John Sabre and the entire Colorado Law School team. And thank you all to all of you for joining us tonight. As Jim mentioned, these talks in some ways have really been amplified because of the digital approach we now take. And I see we have at least one attendee from our neighbor to the north. So it's great to see that the talks are reaching a broader audience. Let me just share my screen quickly, and we'll be off to the races. So hopefully that screen share is taking up half your screen, and you can do with the other half what you want. As Jim, Dean, and I explained, I'm talking today about my book, which just came out last week, entitled "Privacy at the Margins." And the book looks at, this is the only slide with text, so just bear with me, and the rest will be all pictures, which hopefully I've given due copyright attention to. As it stands, I mean, I began thinking about privacy when I was in private practice, partnering with the ACLU LGBT and HIV practice, looking for a jurisdiction that was potentially friendly to a lawsuit challenging restrictive gender identity or gender markers on government identification documents. And we ended up settling on Alaska to successfully bring, or they eventually successfully brought a suit challenging restrictive gender ID laws on driver's license in that state. And through that research, I began an interest, which has continued, looking at the ways in which privacy rights might be used to further anti-subordination ends for a variety of intersectional marginalized groups. And over time, one common barrier that I identified in the legal landscape was that privacy rights essentially do not exist in public space or once information has been exposed to another. In other words, legal privacy rights are defined based in part on lived privacy, what you are functionally able to keep secret. And of course, the more interconnected we've become and the more wide-ranging surveillance technologies have become, means that as it becomes functionally more and more difficult to keep information private, so too are our legal privacy rights extinguished. That observation is not is one that many people have observed, but you know, what I view as part of my intervention is to really to show how that legal landscape is particularly damaging for many marginalized communities who cannot, who are both targeted to a disproportionate degree for surveillance and who may lack the means to build effective privacy safeguards. That is, they can't build the literal and technological fences to keep peering eyes out, meaning that their legal privacy rights are diminished along with their lived privacy. So why is it? Why are we in this situation, this legal landscape where privacy rights are defined so narrowly? I argue that it's in part because privacy has been conceptualized really abstractly and universally as advancing a handful of values. And to be clear, I don't disagree that privacy advances these values of freedom of thought, freedom of association, dignity, and other indirect benefits. But I believe that if we focus both on a discursive societal level in the way we talk about privacy, but also in terms of constitutional doctrine, and understand that in this social context of widespread surveillance, that these subtle but important efforts that individuals are taking to guard their privacy are not just inward looking, okay, not just designed to create a sanctuary for freedom of thought, but they are outward facing, they are expressive, and they're expressing resistance to the surveillance regimes, then this will have a couple of different implications. One, on a doctrinal level, it may provide these efforts to maintain privacy protection under the First Amendment as expressive conduct or symbolic speech. And once we recognize that, that will hold particular benefits for many marginalized communities who engage in these efforts of privacy resistance. The talk today, as you may have already gleaned, is going to focus mostly on privacy in public space, but I will at times also talk about information disclosures. I'm happy to talk about more about that in the Q&A as well. So the legal landscape, as I mentioned, in a variety of legal contexts, the law, whether it be constitutional law and the Fourth Amendment, which is the principal constitutional provision protecting individuals vis-a-vis government surveillance, but also in the privacy tort law context, which provides protections in theory between individual citizens and corporations. The law has been crafted so that once you expose information to the public, once you walk out your front door, you lose legal privacy protections over that. And so that's in a series of cases, the Supreme Court has said, for example, even if you are privileged enough to own property and be on your property, but you're out of doors and the government conducts aerial surveillance of your property, and it's a huge piece of property, you're still out of luck. It was you were within view of the government from a public vantage point, and so therefore you lose privacy, all privacy rights. And this principle has been extended so that the government can, in effect, post a camera outside of your house without a warrant for a prolonged period of times. The Supreme Court has said once you put stuff in the trash and put it on the curb, you lose privacy protections. No warrant is required. And the bears here in Colorado and Boulder have taken advantage of this rule and pilfer our garbage at will, as could the government or anybody else. And these rules, crafted in many instances long ago, before the technological advances that have occurred in the past few years, have enabled police departments and other government actors to, in effect, create universal surveillance, both through CCTV cameras, but also police worn body cameras that have often been instituted in the name of civil rights, but are in effect another surveillance tool. And this information here, I've pictured an Axon camera developed by the company called Axon, and also emblematic of the vast degree of sharing between the government and the private sector. But there are many other examples, drone surveillance, et cetera. The list goes on and on. What this means, so not only is the government surveillance really powerful and wide-reaching, but also our own surveillance. We have, in essence, surveillance has been outsourced. We surveil ourselves, and sometimes that surveillance can serve important civil rights purposes as well. Here I pictured a protester recording a protest, and undoubtedly recording, for example, of police abuse has served important government accountability functions. But that same recording, that same outsourced recording that goes on at these protests also diminishes those protesters' rights vis-a-vis the government, right? Because that information is being shared widely and ubiquitously. And of course, we do this every day when we log on to social media and share sometimes the most intimate aspects of our life. So the legal landscape is, broadly speaking, extremely permissive with regard to both corporate and government surveillance once we've entered the public realm. For communities at the margins, this doesn't just mean a loss of privacy. And part of my book is to underscore that for communities at the margin, losing privacy rights often leads to much more consequential harms than just a dignity injury, but it materially and concretely can lead to discrimination or violence, or as I pictured here, the loss of your home. The lack of privacy in public has been used to justify moving homeless people and their temporary or to medium-term homes from public property. Without privacy in public, okay, building your temporary shelter on a public sidewalk means that the government doesn't need, in certain instances, has been granted carte blanche ability to run roughshod over people's homes and temporary homes and lives. for community of color. The lack of privacy in public has been used to justify broken window policing, actuarial policing that has sent a disproportionate degree of police officers to communities of colors. And to be clear, that police presence is itself a privacy harm, right? Because the police are there and they are surveilling you when you go out your door, and that contributes in turn to higher rates of incarceration among communities of color, because there are more police there, and that creates a snowball effect leading to further privacy harms, stop and frisk being an example of that. And then, of course, arrest and incarceration, which are themselves, entail further degradation of individuals' privacy. And there are reports that activists, Black Lives Matters, and other activist groups have been subject to targeted surveillance, and that's nothing new. Civil rights activists of all kinds have been subject to both state, local, and federal surveillance for decades. Religious communities have also been targeted for additional surveillance, and there are examples of the FBI and the New York Police Department and New Jersey Police Departments targeting Muslim communities for additional surveillance and infiltrating mosques in order to get a better handle on what these communities are doing. Likewise, queer communities, gender nonconforming individuals, trans communities, gay and lesbian men have been subject to additional surveillance, and law enforcement officers have used the lack of privacy in public to go into, for example, queer clubs and require and arrest people who are not wearing the appropriate number of gender appropriate clothing items. And here I've pictured two queer rights activist icons, Sylvia Rivera and Marsha P. Johnson, who were subject to harassment by police because they didn't conform to traditional gender norms. But make no mistake, this policing, and again, this is part of the purpose of the book, is to emphasize that this surveillance of marginalized communities is historic, but it's being reinvented all the time. And there are new ingenious ways of surveilling and targeting these different communities. So, it used to be that the police would just go into a gay bar and arrest whomever they wanted. They're less likely to do that today, but people on the street are still subject to, queer people on the street are still subject to harassment by police, leading to the phrase "walking while trans," that it's been criminalized to walk while trans because you may be arrested by the police. But in school districts across the nation, and government bodies have attempted to exclude people from using bathrooms consistent with their gender identity, and force them into a bathroom that does not comport with their gender expression or gender identity, potentially outing those people as gender nonconforming in that bathroom and subjecting them to violence. If someone in that bathroom, it becomes uncomfortable. So it's a form of, differently, it's not a carceral surveillance, but it's a form of administrative surveillance that has severe privacy consequences for gender nonconforming people. And again, I've talked mostly about privacy in public space, but I want to talk a little bit about informational privacy, that is disclosure of information, sensitive information about oneself. The same baseline rule in the legal landscape, no privacy once it's exposed to anyway, has been used to undercut efforts to protect people's intimate information from being disclosed, particularly when it comes to marginalized communities. So here I pictured Oliver Sipple intervened to potentially thwart a attempted assassination attempt on then President Ford in San Francisco in the 1970s. because of this, he was in subject to newspaper reporting, and the newspapers reported that he was gay. This had serious ramifications for Oliver Sipple and led to a breakdown in relationships with his family, who did not know he was gay. So he sued the newspapers, claiming that this violated his privacy rights. He sued in tort, and the California courts said no dice. They said, look, you had gone out in public, you'd gone to gay bars, your sexual orientation was not completely secret, okay, and therefore you have no privacy rights over that information. It was totally free game for the newspapers, which, when you think about it, most people's sexual orientation does not exist in a vacuum, right? Like, to the extent that they are not closeted, and sexual intimacy often requires a partner, that information is going to be shared, at least within limited confines. And under this rule, many people, not just queer people, have had information about them widely disclosed, and courts have said that's perfectly permissible, because you did not keep that information completely secret. These rules have had particularly damaging effect for women as well. For example, there have been lawsuits brought by women who have attempted to access reproductive health services, and they've been videotaped by anti-abortion protesters as they enter the clinic, and they brought suit against these people, saying, look, you can't videotape me when I'm trying to exercise reproductive health. And the courts have said, well, you walked outside, so the information was exposed. You're out of luck. Similarly, victims of non-consensual pornography, so-called revenge porn, have brought lawsuits against websites hosting intimate videos of women, and the courts have said, well, this website wasn't the first to host this video. It was hosted on another website, so the information was already out there. You're once again out of luck. So you see that these rules of no privacy once you go outside, or once information is exposed to anyone else, have a particular salience for members of different marginalized community, and further, in many instances, their subordination. So I think I accidentally skipped a slide, but why? How did we get here? Well, I think that part of the problem is that privacy, we don't really link it up to anti-subordination and equality as squarely as we should, or we haven't done so historically. Instead, privacy has been conceptualized as being important to the freedom of thought, for example, that it creates a space where we can develop thoughts, and that's really beneficial, particularly to the First Amendment, because it allows us to then go out and utter wise thoughts in the marketplace. Similarly, we may need privacy to make our associations meaningful in practice. And so the Supreme Court has said, in a case involving the NAACP, that forced disclosure of membership lists of the NAACP was unconstitutional under the First Amendment, because it would infringe on the NAACP's freedom of association. Similarly, and here I've pictured Judge Brandeis, who, along with his then law partner Samuel Warren, wrote a famous article back in the late 1900s called The Right to Privacy, and they really conceptualized the right to privacy as being key to human dignity or personhood. If Brandeis doesn't help you remember this concept, maybe the Queen will. That privacy is very helpful to living a dignified life, which arguably the Queen has done. The privacy has also been conceptualized as incredibly home-centric, right? That, okay, well, as long as you're in the home, privacy there is sacrosanct, and even conservative members of the court, sort of, not the justices who haven't typically interpreted the Fourth Amendment expansively, have recognized that in the home, privacy is well protected. And of course, that privileges people who can afford homes and afford to build walls. Again, I don't disagree with any of that. I think that's all fine and good, but I don't think that really captures why privacy matters to marginalized groups. For marginalized people, privacy is often a matter of life and death. And is key to preventing direct negative consequences, including violence and discrimination. So part of my intervention is to center the anti-subordination benefits of privacy protections, and in so doing, one way I think we can get better anti-subordination is understanding how many marginalized groups are engaging in acts of privacy resistance, and that in this social context of widespread surveillance, little efforts to protect your privacy take on a heightened expressive dimension, and that the government and corporate surveillors understand it as expressive. They see what the marginalized communities are doing to protect their privacy and then target them for additional surveillance. They understand that the members of these groups are saying, no, thank you, and expressing resistance, and they're targeted for additional regulation because of that expression, which is a big no-no under the First Amendment. So I'm going to talk about a few examples of, I'm going to lay the theoretical groundwork for why I think acts of privacy, functional efforts to maintain privacy are expressive, and then I'll go through a few examples. So here I pictured philosopher Judith Butler, and she, along with others such as Erving Goffman, Michel Foucault, have helped us understand a bit about the concept of performativity. And without getting too theoretical, I think their interventions are actually quite digestible, which is to say, basically, we all do things in public and in private, and those but those performances, our actions, do not exist in a vacuum, right? There's a social construct or context that makes our actions understandable to others, okay? So, Butler scrutinized this in the context of gender performances. And what she said is like, men dressing a certain way, wearing their hair a certain way, only has meaning and is only read as masculine because of the social context that has coded that as masculine. There's nothing inherently masculine about the fact that a man may wear a button-up Oxford shirt or pants more frequently than women historically, right? That's not a priority. That's not in our DNA, right? That's all social construction. And so when people deviate from that or conform to it, they reinstitute those norms, okay? They help entrench them or resist them. And because of that, the social norms, acts that deviate from the norm are understood as expressive. People understand them as going against the grain, and they help reshape the social norms, right? So that they don't just, it's not just a one-off expression, but they can help basically reconstitute the tableau, the painting. So Butler was addressing this in the context of gender performances, but it has just as much valiance to privacy performances, and I think to First Amendment jurisprudence more broadly. And here, I just want to talk a little bit about how I think that the Supreme Court in their expressive conduct jurisprudence actually really gets this. They get the social context is key to understanding expressive conduct as becoming expressive. And here I pictured Mary Beth Tinker from the famous First Amendment court case of Tinker v. Des Moines, right? So all Mary Beth Tinker and her comrades did was wear a black armband, okay, to school. In a vacuum, that doesn't mean a hell of a lot. And in different contexts, it can mean different things. Like it can mean mourning, like that you're mourning for someone. But in this context, it was in the context of the Vietnam War, it was read as a protest to that war. And the school understood it as such, right? And then they regulated her and punished her for wearing this armband. And the court said she was expressing something. Again, in the abstract, the black armband doesn't mean a whole heck of a lot, but in the social context, under which it was being worn, it meant a great deal. And regulation of it for that reason was impermissible. And there are many other examples where the Supreme Court has recognized that conduct can be expressive. Burning the flag is one such example, but there are many other recent examples of this in our society. Colin Kaepernick and the effort by NFL players to take a knee during the national anthem, right? Taking a knee in the abstract may not be communicative, but in the social conduct of the national anthem playing at a football game, it takes on a really heightened expressive value. So what does all this mean for privacy? What it means is that marginalized groups have been taking efforts to resist and express resistance to surveillance regimes. They've been targeted for that resistance. And once we recognize this, I believe that these efforts to maintain privacy should be entitled to robust protection as expressive conduct under the First Amendment, rather than the Fourth Amendment landscape, which I outlined at the beginning, which has left them pretty much out of luck. So here I pictured, the part of the Million Hoodie March, which grew out of the tragic killing of Trayvon Martin, who was targeted, of course, for his race, because of his race. And make no mistake, many marginalized groups are not just targeted because of their privacy performances, but it's the privacy performance coupled with their marginalized identity that the government is often targeting. So, there are phone calls between Trayvon and his friend where his friend Rachel Gentel basically said, put down your hoodie, you're being targeted. There are many other examples of this. Mitu Gulati and Devin Carbato have written about how men of color will signal compliance with law enforcement by putting their hood down, by surrendering privacy, and likewise signal to try to maintain privacy signals somehow a lack of compliance. And the government targets people of color for not for resisting efforts to surveil them. Economic protesters such as the Occupy group also have tried to resist government surveillance, and they've been targeted with the enforcement of anti-mask laws for resisting that surveillance. They've been arrested for violating the laws that say that you cannot wear a mask in public. The government says that these masks are in effect intimidating, and uses that as a basis for arresting them when no other illegal conduct is occurring. And now we're seeing examples of what I call performative privacy at scale, right? And this is, COVID has amplified this. People wear masks for lots of reasons, public health reasons, and privacy. But even before COVID, last summer, if you recall, the giant Hong Kong protest where people, thousands of people were wearing masks to protect themselves from government surveillance cameras. Similarly, the police started wearing masks because they didn't want to be surveilled by the protesters and have their identities exposed. People understood that privacy was a valuable commodity, and that wearing a mask was expressing resistance to surveillance regimes, and protesters were punished for wearing masks. There are more ultra forms of this, right? There are some really clever people creating fabrics or makeups that will subvert facial recognition software or thermal detection, for example. And these are just really sophisticated forms of privacy resistance. But as I think the examples of hoodies and Guy Fawkes masks show, there are much more, in my view, significant but Quixotean examples of this occurring every day. Likewise, Muslim women have been targeted for trying to maintain some modicum of privacy over their bodies. And I should add, and I'm just going to give a couple more examples of the marginalized communities who are using performative privacy to protect themselves. Transgender people, instead of outing themselves when they use a bathroom that doesn't correspond with their gender identity, they use the bathroom that does correspond with their gender identity. In effect, attempting to keep aspects of their identity private, performing privacy in the face of government bathroom bills. People online frequently will use encryption technology or Tor to hide their online movements, and there's evidence that the government has targeted people who do this for additional surveillance. So if you care about your privacy, take functional efforts to protect it. The government will target you. They understand it as expressive, as expressing something, as expressing resistance, and go after you even further. So I talked mostly about government surveillance. I want to back up in my closing moments and talk a little bit about private party surveillance and why I think I'm emphasizing the First Amendment expressive dimensions of privacy. It can pay dividends with respect to regulation of corporate surveillance as well. So here I have a slide referencing Clearview AI. They're a company that has said that they have a First Amendment right to scrape social media platforms, take the faces from those platforms and use it to train facial recognition software that they then sell to law enforcement. There have been some efforts to regulate this and Clearview has said, no, you cannot regulate me. I have a First Amendment right to access that publicly available information, right? They go back to the legal landscape and say, this was exposed to the public. And part of the reason why it's protected and why we have no rights in public in theory is because of the First Amendment right to information gather. So Clearview says they have a First Amendment right to this information. Well, if we understood that there were competing First Amendment rights at issue, including expressive privacy rights, then I think government regulation of Clearview's behavior would be on a stronger ground, right? Because you would be pitting First Amendment interests against First Amendment interests rather than Clearview's First Amendment interests against an amorphous privacy right grounded in, for example, dignity, which hasn't held a lot of judicial purchase. So, just in closing, I want to note, our world is facing lots of problems, marginalized communities in particular, and there's a growing awareness of that, which is absolutely critical in my opinion. I don't think privacy is a panacea. I'm not trying to sell you snake oil, but I do think the most critical aspect of solving subordination is calling out subordination and addressing it. But I do think until we have full lived equality for all members of society, that privacy can serve as a form of harm reduction, right? Mitigating material concrete harms for many communities at the margin. So I'll stop there and happy to take your questions, critiques, and virtual rotten fruit. So thanks very much.
Thank you, Professor Skinner-Thompson, for insightful presentation. I was taking some notes. I'm going to look in the questions. We don't have any questions yet, but we'll give folks, already a question as I said that. This is from Anitra Parks. Can you speak to privacy and DNA testing?
So thanks for the question. I mean, I think that this the question really gestures to a disturbing trend in my view in our society, right, where everybody is surrendering their information to companies like 23andMe, Ancestry, et cetera, to find out more about their past. And as interesting as that might be, maybe useful in some health contexts, yeah, I think that it's really dangerous given the current legal landscape. Surrendering that level of intimate information to private parties, is not only giving them some access, but potentially giving law enforcement access as well. So I personally have asked my mother, who expressed an interest in doing this, not to do that, and explained to her that that doesn't impact just you, it impacts me, my brother. So please refrain.
Thank you. We are open for questions in the Q&A section. One of the things I was reading about in reference to your book is the numerous privacy violations. And I'm wondering if you have another example that you didn't have in your presentation that you'd like to share with the group.
Well, I guess maybe, thanks, Georgia. I'll use this as an opportunity to talk a little bit more about privacy disclosures. And what I see is the unequal effect of privacy law as applies between privileged people and non-privileged people. So, switching a little bit from the privacy and public Fourth Amendment context to the informational privacy, privacy disclosure laws, there have been some high-profile examples, where privileged people have prevailed in their privacy lawsuits, and Hulk Hogan's a good recent example of this, right? So Hulk Hogan brought down Gawker Media because Gawker posted a clip of a sex video between him and a woman named Heather Clem, and he sued Gawker and said, "You disclose my personal information." Sued him in tort, and Hogan made it pretty far and ultimately settled this case for millions of dollars, and the lower court had treated his claim favorably, notwithstanding the fact that, given the fact that he's a celebrity, he's actually under the doctrine entitled to less privacy rights than the average citizen. But he prevailed, and prevailed to extraordinary degrees. Contrast that with other cases, also from Florida, where, for example, an allegedly gay man goes to church, and his pastor discloses to the congregation that he's gay. The court says, again, no success. That wasn't widely disclosed enough, and therefore you don't win. So you have a person from a run-of-the-mill to marginalized background trying to bring a privacy claim, doesn't succeed, where you have a privileged person succeeding on very similar claims.
Okay, we have a couple of questions in the queue. John Hostad says, have you researched and can you discuss the differences of personal privacy law in the United States and the European Union? Example, online data and right to forget.
So I think the question is driving at, how are things across the pond? And I guess I would say things across the pond are better. Europe has enacted the GDPR, the General Data Protection Regulation, which provides, if you've ever even visited a website of a company based in Europe, you're probably familiar with the heightened privacy protections you're afforded, and all that is required of you in terms of consent and opting in. So, they have recently taken a lot of steps to protect consumer privacy and data privacy. There are efforts on that front in the United States. California has a new privacy regulation that recently went into force, and we'll see what happens as more and more states start to regulate. It'll be interesting to see if tech companies actually want a federal privacy law, because that will prevent them from having to comply with a bunch of different state privacy laws, and they may ask for some sort of preemption provision. You can imagine that happening in the not too distant future. There was a comment I don't know if everybody can see this, but noting that the Hulk Hogan actually prevailed in his jury trial. That's true, but he didn't actually get the full amount that the jury awarded. He settled for a fraction of that after the fact because there was an appeal pending.
Right. We have several questions that have come in. This question from Courtney M. In a necessarily digital environment during the pandemic, do you have any suggestions on how we can resist or mitigate privacy invasions while still being productive and engaged with our communities?
That's such a great question. I mean, you know, we were already living a lot of our lives online. We're doing it now to you know, at scale, and I guess I don't want to point anybody towards endorse any specific software or anything like that, but definitely, you know, one book I'll recommend is called Obfuscation by Finn Britton and Helen Nissenbaum. It's a very thin book, but it's got a bunch of great examples of ways in which you can bolster your online and cellular privacy. And Yale actually, their ISP program, I think this week has a speaker talking on similar topics. You know, what can you do as a technical matter? You know, I think some of them are more well known, like the chatting software called Signal, which has better encryption, and there are different email services you could research as well.
Well, we need to be informed, that's for sure. Our next question is from Flo Phillips. The problems that you've described are serious, but what's the answer? Can you put the toothpaste back in the tube?
It's a great question, and I think that a lot of people would say, yeah, privacy is dead. The toothpaste is out of the tube. The genie's out of the bottle. I disagree. I think that we are at a moment where awareness regarding why privacy matters is actually increasing. I mean, I think that people are starting to not take it for granted. And I think that given, yes, the social landscape we've shared a lot, but we can still change our behavior and the law can still react to that behavior. So I definitely appreciate the pessimism embedded in the question, and don't dismiss it at all. I mean, many people would agree, but I'm slightly more optimistic. And again, you know, the part of the title of the book is a play on words. I don't think privacy is everything. I don't think we're going to get complete privacy, but I think that privacy at the margins of our lives can materially benefit our lives, right? Like, am I going to have privacy over everything? No. But if I keep privacy over certain intimate details, is it going to materially benefit our lives? I think the answer to that question is yes. So I think it's worth trying to protect it at the margins. And I think it has particular benefits for marginalized communities.
We still have a few more questions here. I think you hit a chord with all of us thinking about our privacy. Yesenia Delgado asks, with the recently launched COVID contact tracing app, do you see any potential dangers or violations in privacy rights for users who opt in to use the app? The app uses Bluetooth to transmit an anonymous ID. How do you see this impacting community members who live in densely populated areas?
Thanks, Yesenia. I mean, it's a great multi-layered question. And I guess I will talk, I'll step one step back and say my expertise regarding public health surveillance comes from the HIV standpoint where the, the concerns are slightly different, but I do think that the HIV epidemic does hold some lessons for us. And the first is that, this one similarity between the epidemics is the testing is key, and we want to encourage testing, right? Because that is not only key to treatment, okay, but also key to preventing spread. So we want to encourage testing. In the HIV context, we were very concerned about stigmatizing the disease. And so anything such as laws that criminalize HIV transmission, that stigmatize you from getting tests or knowing your status, we now know were really bad ideas, even though these laws exist and are still enforced in many states. And we also know that privacy is key to that, right? Key to encouraging people to get tested is not only a lack of punitive response if you do get tested and are positive, but also privacy over that. So you don't experience further stigmatization. And so in the HIV context, yes, there was contact tracing, right? Like, and if you test positive, that might be reported up to the CDC on a confidential basis. Again, not a totally private basis, but a confidential basis. There is names-based reporting for HIV in the United States. So what are the lessons for that for COVID? I think we still need to respect people's privacy and encourage them to get tested. And when they test positive, respect that privacy. Now, that doesn't mean you can't engage in contact tracing, but that contact tracing should be defined by what is a relevant contact, okay? Which is to say, not all contact, just like in the HIV context, when they do contact tracing, HIV is only spread through very limited kinds of behavior, sexual contact, unprotected sexual contact, and depending on your kind of sexual contact, the risk varies as well. So that's the relevant contact, and intravenous drug use. Not every contact is relevant. In the COVID context, I think we need to be very concerned about what is the relevant contact for contact tracing. Now, I recognize that COVID spreads much easier than HIV. There's no doubt about that. So the relevant contact is going to be defined more broadly. But I am slightly concerned about the contact tracing apps, because I'm not sure they are. I don't know. I don't know if the app developers know yet whether they are calibrated or fine-tuned enough to actually drive us towards relevant context versus scooping in more people than is actually useful. And to my knowledge, I don't know. There may be some studies out now proving that they're more effective, but let me just say that I'm skeptical of them, and I personally declined Apple's invitation to have them contact me.
As did I. The next question from Amber. Thank you for the great presentation. What are the limits to your book and research? What are the privacy areas where you see the least amount of answers available to us?
So thanks, Amber, for the great question. I will say, I think the Yesenia's question on COVID and public health is one that I am definitely interested in, and I think we need to be paying close attention to. Other issues that are of particular sort of unanswered areas. I think that privacy in terms of our intimate lives is an area we really need to pay more attention to, particularly, again, because of COVID. We're living more and more of our lives digitally, and that means more and more of our intimate lives are going to be lived digitally. And I think that we need to pay more attention to online dating apps and the privacy safeguards that they are and are not providing for individuals. I also think, I gestured to this earlier, but I'm very concerned about the number of surveillance technologies that are being ushered in the name of marginalized communities very quickly without research, and that I see as, in essence, further subjugating those communities without doing much. And you know, body cameras are a good example of this. Police body cameras, right? They've been unveiled at an alarming pace. The group called Upturn has some great statistics canvassing all the body cam policies that have been implemented across the United States. Oftentimes this has been done without community input, but even when there has been community input, I think that the input that's been sought has been very top line, like, do you support this or do you not? And without like gradations, like supported under what terms? Like, you know, what are the retention policies? What are the access policies? When is the camera going to be on? And I think that there has not been as much nuance in these conversations as I would like. And in any event, even when the cameras capture, right, the whole reason society wanted cameras, in theory, was to protect marginalized communities from more police violence, right? Well, is that actually leading to greater accountability? Undoubtedly, it has served some documentary purpose, and there's been, you know, we are better informed about the degree of violence against communities of color and queer people by police. But has that led to concrete change? Is the body camera meaningfully different from a citizen recording camera? And what are the costs of the camera? Yet it's also being used as an evidence collection device to incarcerate these people from the same marginalized communities. And I think we need to really problematize emerging technologies more at the front end before we just start unrolling them everywhere. I mean, it's basically, you know, what some people call the data smash and grab. We just like, we don't and this line from Jurassic Park, right? Like where the scientists are like, they were too focused on answering whether or not they could do something that they'd never stop to ask whether they should do something. And I think that applies to a lot of our technological advancements, and they're great people trying to advocate for breaks and more ethical design principles in the privacy space.
Well, I think we should all pick up your book as well. Yeah, pick up your book and show it. We have 3 questions left in the queue. We're copying those, and we will get those answered for the folks who have asked those questions. I'm going to turn it back over to Dean Anaya.
Wow, Scott, what a great discussion, and congratulations on the book.
Jim.
I have a ton of questions for you, but I'll take those offline with you.
Great, look forward to them. Thank you. Thanks for having me, Jim.
Yeah, no, thanks so much. Really great presentation, and thanks to everybody for joining us and for a great discussion. So by the end of the week, everybody attending this evening will receive a link to the presentation and survey so you can share your thoughts with us, and Colorado attorneys who are attending will receive a link for the CLE affidavit. I want to add a word of thanks to our terrific staff for making this presentation possible. Thanks to Yesenia Delgado and Georgette Vigil, who have already been mentioned, also to our terrific and wizardry tech staff who have really been keeping us going both in the classroom and in our events. Before we close, I'd like to announce that as part of our Anti-Racism and Representation Initiative, we're hosting a lecture series focused on the relationship between race and the law, with the objective of generating thinking about the barriers to and also the possibilities of the law serving as a vehicle for racial justice. The next Race in the Law offering is on December 4 from 11:30 a.m. to 12:45 a.m. So a lunchtime event. That lecture, which is on race and the Constitution, will be presented by CU Law Professor Helen Norton. To register for that event, visit the Colorado Law Events calendar at cu.law/events. Again, thank you all for joining us, and I wish you a wonderful rest of your evening. Be well.